All right. Hello, everybody. My name is Zahra Hosseini, and we have Kathryn Fix here with us as well. So I'll introduce myself, and then Kat will introduce herself, and then we'll start talking to you guys about what we are doing. So again, my name is Zahra Hosseini. I'm legal counsel at A Woman's Place. And Kat and I work together, and we've put together this presentation for people who might be interested in this area, and also to acknowledge that November is Family Violence Awareness Month. So we're putting together this presentation just to reach out to workers and just the public and let them know about a certain area and how it affects women in domestic violence situations. So I'll pass it along to Kat now.
Thanks, Zahra. So Zahra kind of mentioned, my name is Kathryn. I am one of the family violence counselors at A Woman's Place. And I've worked there for a while now, and I've gotten the good fortune of working with Zahra and connecting with some awesome people here in Winnipeg. Before I kind of move on and talk a bit more about kind of some of the services that we offer at A Woman's Place, I would first like to acknowledge that we are on Treaty 1 territory, and that the land on which we gather is the traditional territory of the Anishinaabe, the Cree, the Oji-Cree, Dakota, and Dene peoples, and the homeland of the Métis people.
Perfect, thank you, Kat. And yes, and Manitoba has, it is our anniversary. So we owe a lot to First Nations people, especially Louis Riel, who is the father of our province. So yes, so thank you for that. And on to who we are. I'll just open up this link, and then I'll let Kat tell us who we are.
Perfect. So we're A Woman's Place, and so we fall under the umbrella of Norwest Co-op Community Health. And so at A Woman's Place, we offer services to women who have been in abusive relationships, or are presently, or are thinking about leaving those types of relationships. And so when we talk about abuse, that can be anything from emotional to psychological to sexual to financial to physical. And so there's a broad spectrum of abuse. We offer counseling, we offer support workers for folks to kind of support women in the community. We also have Zahra, and she'll kind of talk a bit about her role. And then we also have a child therapist that we offer to children who have witnessed abuse. And so if you can look, we're open Monday to Friday, 9 to 5. We also have a support line, which is 9 to 5. So just a place where you can text if you have any questions, or you're seeking help, or you want to know more resources about your situation, or about services that are offered to women who are fleeing abusive relationships. And there is our phone number, and then the number that you can text.
Perfect. And yeah, so if this is our website, you guys can go here and just click on domestic violence chat, and it'll tell you, hey, how does it work? How can you connect with us? And then click here to chat is an option. And during our presentation, we'll be showing a lot of things online. And the reason that we have done that is just so that you can consistently go back to an area and say, hey, I saw this online. That's how a lot of information can be shared, and up-to-date information, hopefully. If things are updated on the website, that's where it's easy to access. We also, I'll go back to my thing here. We also are on social media. So the first one I can show you guys is our Facebook page. So A Woman's Place is, again, part of Norwest Community Co-op, and Kat and I are part of the domestic violence team. And here is our Facebook page. So if you need help, again, you can go to Facebook and be like, hey, I forgot their phone number. And you're often on Facebook, you can connect with us there. The other part that we do have is our Instagram. So again, here we are. And again, this is where you can find us. And just if you're looking for resources, we'll try and be posting things up here so that you can follow along. Close these. All right, so now we're on to our presentation. this is a presentation on the Hague Convention on the civil aspects of child abduction. And when we're talking about civil aspects, we are really talking about family law aspects of it. We are not talking about criminal aspects. So one thing that I just want to say, that this presentation is to share legal information and it is not legal advice. So you should not rely on this presentation as legal advice. So the purpose of this presentation is to provide general, non-tailored information about the law. And when you're looking for legal advice, one of the things is it's often tailored in a fact-specific situation, which is your situation. This presentation is not that. So if you have any questions specific to your case, please seek out legal advice. And if you are a Manitoba resident and you are experiencing domestic violence or you have experienced domestic violence, please contact us or any other resource that you are comfortable with, but definitely contact someone. And if you do contact us and say, hey, I'm looking for some legal advice, you'll be connected to one of our counselors. And then we'll do a determination of whether or not you fall into our mandate here for legal advice, and then you'll be referred on to our legal counsel, which is me. So we'll have a chat. But at this time, this presentation is not that. This is just legal information only. All right, so if we are talking about the Hague Convention of Child Abduction, the first thing we thought about, what should we show? And we said, hey, if this is a question that comes up, how do we, most Manitobans, how do we kind of search out for information? Well, we make phone calls for sure, but we also search online. We Google it. So here is what happens when we just put in Hague Convention Child Abduction. Again, this isn't the full name of it, but the full name we can see in the corner here. So Hague Convention on Civil Aspects of International Child Abduction. So then you can actually, the first thing that shows up, obviously not the ads, but here is the first thing that shows up. This will take you to the website for the convention, and you also have Wikipedia as well available. All right. So then we say, okay, so where can I find a copy of the Hague Convention? Again, we'll go to the next portion here. And this takes us to the website. So let me show it again. This is the website of it, and then text of the convention. Here we are. They keep this up to date. Okay, so what is the Convention on Civil Aspects of International Child Abduction? Well, here what we're talking about is if a child is removed, okay, from one state, right? And when I say state, I mean countries. I don't mean the US states. That's not between US states. It doesn't attach to each other. So if a child is removed, the countries that have signed up for the Hague Convention, they are telling each other, hey, we have this particular objective in mind, right? So it's to secure the prompt, I'm just reading Article 1 here, to secure the prompt return of children wrongfully removed or retained in a contracting state. So wrongful removal is you remove them. Wrongful retention means, hey, they were supposed to be there for a period of time, but now you've retained them inappropriately. And then again, the number B, Article 1B, is to ensure the right of custody and of the access under the law of one contracted state are effectively respected by the other contracting state. So they're saying that, hey, if there is custody rights and custody obligations and custody rights in one state, the other states will respect it. So nobody's coming in and spending time and that children, when they move from one state to the other, now you have a duality of jurisdictions. So that's the reason for it. Article 2, and this is quite important, is that the states, the countries that are involved in the Hague Convention have accepted the Hague Convention. They will try and resolve things, so they shall use the most expeditious procedures available to try and resolve things. So this is again the idea that, hey, if this happens, if children are removed from one country and taken to another country, and the Hague Convention applies between these two countries, they'll try and move it out as fast as possible and be expeditious about it, because they don't want for this to become a long, difficult process that they're dealing with. So this is the Hague Convention. As we go through it, it gives quite a bit of explanations. It tells you, and we'll talk about this a little bit later, it talks about, for example, what is the central authority? It talks about, and the part that we will eventually get to, which is important in Domestic Violence Awareness Month, that's why we're bringing some attention to it, is Article 13b. Okay, so this is an exception under the Hague Convention, and we'll talk about it a little bit more, but in general, Hague Convention is, hey, children should return to where there is their habitual residence if they meet all the other factors, but under Article 13b, that is an exception. And the exception is there is a grave risk that his or her return, so this is, we're talking about the child, we're not talking about the other parent who has taken the children, but the child themselves. So there is a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. So we'll talk a little bit about that, and that is closely linked to domestic violence, because we do see that, hey, when there is violence in the family, it does affect children. So physical and psychological harm can be, and we'll talk about where the threshold is for this. And we'll be looking at 2 Manitoba cases that deal with that. Yeah, so that's sort of a very quick talk about what we're talking about here. I'll close that up and we'll go back here. So now when I've been talking, I've been saying, hey, I've been talking about contracting states, I've been talking about countries agreeing to the Hague Convention. So now we want to know, who is a party? Who are these contracting states? What is their obligations to the states? What are they doing? And again, you can go back into to the website. Sorry, let's see. Okay, so we're back into the website. So it's child abduction section again. We're going to go into contracting parties. Here is where you're going to get a very long list. And here you have a little bit of information about what this list means. And now, one of the things that it's really quite important to know about the Hague Convention is that it doesn't mean that every single party that is listed here applies to Manitoba. It has to be the parties themselves also agree to be bound by each other. So that's really quite important. One of the examples that I can show is, let's say, hey, we want to, so then it becomes quite a big question of, if I am a Manitoba resident, if my children live in Manitoba, which countries are actually applicable to me, right? So that's quite important to know. So you can have a look at this website that can be a little bit long. So then there is another website. Yeah, so this is a status table again. Okay, so when I was talking to Kathryn, she was like, hey, how do I know which states are Canada based? So I said, yes, that is a very good question. There is on the website itself, there is a giant Excel sheet that you can have a look at and say, hey, where do I fall on the Excel sheet? So I can show that to you. This would be it. So this is again I've gotten this from the Hague Convention as of the 9th of October 2020. It is valid. Again, this is quite confusing to read. So what we have available for you is as part of my the way I like to do presentation is just show you where information is. I know that the province of British Columbia has a website that says, hey, these are the countries that actually are relevant to Canada. Now, family law in Canada falls under provincial jurisdiction, apart from the divorce. So family law falls under provincial jurisdiction, but because Canada is the state, the contracting states that we are involved with, they actually, it does not matter if you're in BC or you're in Ontario or you're in Quebec. The contracting states will remain the same. So you can just go there. So here we are. So the website here, it says, look, and again, here the information about the convention, it talks about the Central Authority in British Columbia. That is not relevant for Manitobans, but the countries are listed. And they have said as of April 1st, 2020, the Hague Convention on Civil Aspects of International Child Abduction was in effect between Canada and the following countries. Okay, so here is our list. Okay, so that's quite important. If you compare it between that, and this is the contracting parties, this is a much longer list. Right? Versus this one. For example, here, we've got Zambia here. We do not have Zambia here. Okay, so it's really important just to know that in this area, it is good to have full information, and we'll sit down and we'll talk about the Central Authority and what that is and how they can assist, and why it's important if something like this comes up, and if you are in Manitoba, to reach out appropriately. And that involves reaching out to police, it's reaching out to support workers, and it's also reaching out to the Central Authority if that becomes an issue. All right, so we have talked about multiple different countries that are signatories to the Hague Convention or have acceded to the Hague Convention, or have ratified the Hague Convention. These will have a little bit of a different meaning, but again, you want to make sure if you are here in Manitoba, it is important what our relationship with that state is. So now we're just going to go and just find some information about the countries, right? So here we're going to go into country profiles. So again, I want to show you how I ended up getting here. Oh, all right. So again, I'm on the first website, and then if you go and click on country profiles, this is where you end up back here. Okay. So these country profiles, each Hague Convention does have some ability to say what kind of evidence are they looking for, how is their application done, what kind of assistance do they provide with the taking parent or the left behind parent, and those are terminologies that are often used. So taking would be the parent who removes the children from their habitual residence, and the left behind parent would be the parent who remains in that jurisdiction. So these are the countries, and they've all provided their country profile. So if let's go and click on Canada, and here for Canada, obviously we said, look, family law actually falls within provincial jurisdiction. So each of the provinces you'll see is listed here. And we'll just go click on Manitoba because that's where we are. And here it is. Here is the documentation that the Manitoba Central Authority has provided to the Hague Convention, and it provides information about people, about the authority to people, and it also provides some good ways of knowing where you go, how you get there, what's important, what's not. Okay, so if you're looking here, we're here. Okay, so you get to the table of contents. It'll tell you about the central authority's contact details, and we'll go into a little bit more about why central authority is quite important. But central authority is sort of like, I would say the sort of the people who have quite a bit of powers, and to make sure that the Hague Convention is actually complied with. Right, and they are lawyers here in Manitoba who work for the Central Authority, and they try and make sure, okay, if another state contacts us and we do have that obligation with that other state, how do we assist, right? And if one of our citizens has a situation where they need assistance from another state, how do we get that assistance? It's really these communications between these bodies, these central authorities, that really assist it. So, and depending on the country, some countries have multiple central authorities like we do, some of them do not. They have one. For example, Australia, I believe, is one of them. So Australia and Canada are quite similar. Our constitutions, however, are different. So that's why it falls a little bit differently. And this is why you're seeing central authority for Manitoba specifically. Okay, so here you can go and click on the central authority contact details. So again, this is saying, hey, where are we? Who is the organization? It's the Manitoba Department of Justice Family Law Section. I will tell you they're experienced, extremely experienced assistants there. So they are very, very on board of making sure that Hague Convention is complied with here in Manitoba. It gives you their address, it gives you their phone number, it gives you their fax number, it gives you their email address, and it also tells you what is their preferred method of communication. Okay, so then we can go back. So, and then this document also tells you, hey, what are the relevant pieces of legislation in Manitoba? So if you go, and relevant piece of legislation means what are the laws, what are the statutes that, that they have available. So they talk about the Hague Convention. And say, yeah, we've also done that. And then they'll talk about, hey, we've got other conventions. So Canada has bilateral agreement regarding cooperation on consular matters with Egypt and Lebanon that touch on family law matters. So they're saying, hey, yes, Hague Convention is wonderful, but we also together, us in Egypt and us in Lebanon, have separate agreements as well. Okay. All right. The other part here that it tells you is it also gives you some idea of what are the procedures in the court system in Manitoba, and then it gives you the link here. This link, I'll show you guys where it is. I believe this link is I'll show you guys later where it falls on the court website. And this gives you the Manitoba Court of Queen's Bench rules. So again, if you click on this, it should take you, oh, they're working on this website. Or perhaps I have not pressed it correctly. But I can show you where that is. So we're back here again. So the two things, so, okay. So the first thing that we were going to look at was, sorry, the Manitoba Court of Queen's Bench Court of Queen's Bench rules. So it's this one, Queen's Bench rules. I'll just highlight it quickly. Oh, sorry, guys, not again. So if you just, if you are in Manitoba, you can just Google Court of Queen's Bench rules and it'll show up. So you want to be in a gov.mb.ca. And here we are. These are the Court of Queen's Bench rules. Now the other portion of that was, let's go back to country profile. This one, right? All right, sorry, we have, here we go. All right, so here we are. And the other part was the protocol. So this is how the protocol starts in our court system. And that is, if this link, I believe, is not going to work, but it is actually available on our court website. So let me show you guys where it is. All right. All right, so where am I? This is our Court of Queen's Bench website. This is our Manitoba Courts website. I'm in the Court of Queen's Bench section, okay? So if you click on the Court of Queen's Bench section, if you then go into family law portion, and then you click on Hague Abduction Convention cases, procedural protocol. So if there is a Hague Abduction Convention, how does the procedure of the court get handled? Here is the procedure from the Court of Queen's Bench. Okay, so it says, hey, yep. So this is the objective of the Hague Convention, is to secure prompt return of children wrongfully removed or retained in any contracting state, and to ensure the rights and custody of access and the law of one contracting state are effectively respected in another contracting state. If you guys remember the Article 1 that I had read to you, it's basically, we've got it here again. Okay, so they're saying, hey, we actually recognize this. And as of, we have the Child Custody Enforcement Act in Manitoba, and that's just taking the convention and saying this is now the law of Manitoba as well. But it talks to you about procedural protocols of how it will work. And part of that is they will say, look, you cannot start off a custody case of care and control of the children or in custody of the children while this is actually before the courts. The Hague Convention comes first. So you resolve that, then you can move on. All right. Kathryn, do you have any questions? No, you're good. All right. Okay. So now we are going to move on and really talk about what is the Hague Convention, right? What are the criteria we need to know? What are the elements that have to be satisfied for it to actually be a piece of documentation that can provide protection? All right, so the Hague Convention, what does it mean in plain language? One of the resources that is quite helpful is actually the United States State Department website. So they talk about it in quite plain language. Okay, so we're just here. We're in, I believe, in important features of the Hague Convention in their website. So what kind of cases fall under the Hague Abduction Convention, Child Abduction Convention? It is here you see that, hey, look, it doesn't actually guarantee the return of the child, but it does give you a hearing if it's actually applicable, right? So you have to, the person who's going to the, so let's say this is between parents and one parent has removed the children to Manitoba. When you go to court in Manitoba, what do you have to show as the left behind parent, the parent who remains in the other state? What do you have to show? Well, you have an application in front of the courts under the Hague Convention, and you're saying, hey, the child was habitually a resident of one convention country and was wrongfully removed and retained in another convention country. We'll talk about habitual residence and how the definition of that has changed in Canada, but you have to show, hey, there has been a movement and the child's habitual resident was somewhere else. Okay, and then the second part is the removal and retention of the child is wrongful and in violation of your custodial rights in where you were. Okay, so this is really quite important because you have to be able to, in a position to show what your laws are in your own country and that this child should not have been removed. And we do see some differences in countries. So in some countries, it's really quite important if parents are married versus if parents are not married, right? So parents who are married will have much more robust rights versus parents who are not married. In other countries, and that would include here in Canada and and the province of Manitoba, that it does not matter, right? So you have to show that, yep, I had some sort of rights. And in some countries, obviously, there's just differences on how things they do it. So if there is one country where, yes, there's difference between married spouses and non-married, that's quite important. The convention must have been enforced between the two countries when the wrongful removal or retention occurred. Okay, so this is, again, when we talked about the website that we got from BC, that is listing that this convention is enforced between these two countries. That's quite important. And then finally, the child is under the age of 16. So if the child is 17 years old, we are not looking at the Hague Convention. Okay. Now, we also are talking about defenses to the application for a Hague Convention return. So how can you say, hey, yes, these first criteria have been satisfied, but for these exceptions, it should not apply and the children should not be ordered to be returned. The Hague Convention makes this quite clear. The one that we will be talking about is that there is the grave risk that the child's return would expose the child to physical, psychological harm or otherwise place the child in an intolerable situation. That's again Article 13b. But here are some other examples. So the child objects to being returned and has attained the age and degree of maturity at which the court can take into account the child's views. This one, more than a year has passed, so the other party hasn't really done anything for a year. So, and then the party asking for the return said, hey, yep, I actually consent to it, or I acquiesce to it. Acquiescence means you haven't done anything. And it's just interpreted to say, look, I don't have a problem with it. The return of the child would violate fundamental principles of human rights and fundamental freedoms in the country where the child is being held. This would be, we have the Canadian Charter of Rights and Freedoms. This would be an exception which that would be eligible to be argued. And the party seeking the return was actually not exercising rights to custody at the time of wrongful removal. So they had rights to the child. There was actually no no actual interactions between them. They weren't actually using the rights. Okay. And then finally, a note here, interpretation of these exceptions varies from country to country. So it does. It really does depend on which jurisdiction you are in and where you are going to ask for the return of the children, on how they're going to be deciding these cases. So we'll be really concentrating on what's happening here in Manitoba when we talk about our cases. All right. We're going to close this. We're going to close this. We're going to go.
Zahra, can I ask you a quick question?
Yeah, for sure.
So you had talked about if the left behind parent was to apply for the Hague Convention after a year, for whatever reason, is it pretty black and white in terms of how they might respond, or is it really depends on the province?
It is not black and white necessarily. So it isn't that, hey, I can hide out for a year and as long as they don't see me, I'm good. We have had cases, for example, where the party that left behind parent thought, hey, okay, I think they've taken my children off to Canada, and I think they have family in this province, so I'm going to reach out to the central authority there and look for them. Right? They couldn't identify the children. Turns out they were actually in a different province, right? So when they found where the children were and said, okay, they're in that province, they started up the application. That province didn't say, hey, no, you've lost your right. They said, no, because of the fact that you were looking and you had been taking some steps, that isn't something we're going to be considering. So it isn't a firm deadline, but it really is case specific. So if questions like that, it really does depend on the case and what has been going on otherwise. Does that help? Yes, all right. Okay. So back here. So again, we're back in the Manitoba, the Manitoba PDF that we were looking at. So again, it talks about the, hey, what happens if there's outgoing applications? So we're the requesting state, Canada is the requesting state, and incoming applications is the requested state. So incoming applications will be the two cases that we look at, because it was the left behind parent was not in Manitoba. The taking parent was. So, and it provides some abilities, some importance things here that says, hey, how do we actually run this for these applications for return? And it talks about some mediation supports that are available as well. So mediation is encouraged as well. And it talks about also what legal services are available for the left behind parent when they come to Manitoba. So legal representation and assistance. Does the central authority provide legal advice regarding return applications? Yes, right? So again, if so again, here in Manitoba, we're one of the few provinces where if your child is moved to Manitoba from a contracting state, our central authority will assist you and they will provide legal representation. And I believe Quebec is another one, and one of the East Coast provinces is another one that provides that, but not many. Ontario, for example, I don't believe they do that. Okay. So what is the role of the central authority in arranging legal representation? So legal representation is arranged by the central authority. Representation is provided by central authority lawyers. Okay, so these are the lawyers who work here in Manitoba for the central authority, and they provide legal representation for the left behind parent. So again, is there a free or reduced rate of legal assistance? Yes, free legal assistance is available. Okay. So, and it's saying, hey, what is actually covered? They're saying here the costs, the court fees, they cover the court fees, they cover service documents, they assist with mediation. So that's quite important. So if you are a taking parent and you are in Manitoba, it will be the central authority, which will be the opposing counsel. On the other side, if the left behind parent requests it, and they do often. Again, this is not an area of law that I have had a case in, but I have not seen any cases where the central authority is not the lawyer who is the lawyer on record assisting the left behind parent. There are, for the Hague Convention, there are some cases where the left behind parent also is facing other portions. So let's say a protection order under the Domestic Violence and Stalking Act that no longer falls under the central authorities lawyers. They get a private counsel for that. And talking about domestic violence and stalking, here is it. So we're talking about provisions for safe return of the children. So they're saying that does the law in your state provide for protection for children from domestic violence or other forms of abuse? And the answer is yes. Here is the Domestic Violence and Stalking Act, which is a Manitoba legislation, which we have protection order designates who work at a woman's place, and we provide legal advice regarding that area as well. But it is listed here, and then obviously the Criminal Code of Canada as well. And then, does the law in your state provide for protection of adults from domestic violence or other forms of abuse? And the answer is yes. And again, they've referred back to the Domestic Violence and Stalking Act and the Criminal Code. All right. So we have now done some work on our country profiles. We've talked about what is the sort of the plain language of the Hague Convention. And we've talked about what are the exceptions, again, in plain language. And again, when we're talking about these exceptions and what it means, if you go back and read the actual convention itself, the articles, you'll be able to cross-reference them with what it is there. Okay. So, Kat, we're about to go into our Supreme Court of Canada case. If you have any questions, ask me, and if not, we'll just jump right in. Sounds good. All right. So when we were talking about habitual residence, we were saying, hey, it's really quite important. Where is this child's habitual residence? Where does this child live? Now here is where states differ on what is the meaning of habitual residence, and Canada itself has switched on what they before used to say was habitual residence and how the case law changed and what the Supreme Court has told us in 2018 of what the definition of habitual residence is in Canada. So again, that's why it's really quite important. The article is written and it's saying that the articles in the convention are written and saying, hey, yes, these states agree to this, but the definitions can vary from state to state. So that's why it's quite important to know where your children are and what does that state believe in. Okay, so we'll go to this case. It's called the Office of the Children Lawyer and Bellev, and this was decided in April of 2018. Okay, and the case itself, what was it talking about? It was talking about what is habitual residence. So And while we're going to look at this, we're going to actually have a little bit of a look around and see where can I get this information? Where are the resources about case law in terms of hate convention? So the first place I'm going to take us to is actually the case itself. This is on Canley, okay? So Canley, if we click here, this is our database. So it's publicly accessible, it is free, and reported decisions, you can find them on Canley. So how can we do this? If you just go to Canley, and we're in the English section, but there is also French as well. If you go here, it'll be the French. All right. So here we'll go. Okay. So here I'm just searching. So you can search for at the top part. You can just say, hey, this is the document text that I think I can find. So let's say I want to search Hague Convention, or just Hague Convention. I can search. So here is a whole bunch of information that you can receive, and these are quite important. So for example, this is the Hague Convention on Child Abduction, a Canadian primer. This was in 2015 that it came out. But let's say we're looking for cases. I can go here and I can click, and here are cases where I can find Hague Convention. And jurisdictions, I can say, I only want to do research on Manitoba. But here they are. Okay. So you can do quite some work on that. The two cases, I'll just introduce it to you guys quickly. Number one is Calicut, and Calicut is the one we'll be looking at. And then number two, it'd be actually number three that's listed here. Mabaya and Negalula are the two that we'll be looking at. Okay. So. And then you can look at legislation where this is mentioned. And if we go back to our country profile, the other one we want to look at is Child Custody Enforcement Act is another piece of legislation that's quite important. And again, it'll talk about, hey, we will enforce, we will make sure that it's enforceable. So here are some additional powers that we have. Okay. All right. So the first place that we looked at and said, hey, you can actually find cases is Canley. And those are Canadian cases that are reported decisions. That it is available and free. The other place that it is available, it's called Enacdat. And I apologize if I'm mispronouncing this, but again, Enacdat is where we can again find this case. This is a Supreme Court of Canada case, and it's saying, hey, when was the decision reached? It's the 20th of April, 2018. It is the final decision. What were they looking at? They were looking at habitual residence, Article 3. And then it provides a little bit of a synopsis as well, and says, hey, what were they actually talking about? And they were talking about the hybrid approach that was adopted and is now the law in Canada. So we'll talk about that a little bit more. But there is a synopsis. So an ACTAT is a search resource where you can go and you can search for any country that's decision regarding Hague Convention cases. Okay, so let's say here we are going to Canada. We can search. Here are the Canadian cases. Okay. And let's say we want to search grave risk. On the side there, we can say, hey, we are actually important for us in regards to grave risk. So why is this important? Well, it is important because you can read the cases from other jurisdictions and how they interpret the Hague Convention, what goes on there. So this is a website that's been provided that they've put together so that people who are they're impacted by the Hague Convention can know. So here, if you go down, latest decisions that they have listed is from Hong Kong. China is not part of the Hague Convention, Hong Kong is. New Zealand, United States of America, we've got an Ontario decision on the 18th of October. So you can, Israel is another one that we sometimes see here in Manitoba. So those are important for you to be able to see what happens if my child ends up in the United States, what happens if my child ends up in New Zealand, and how do they interpret the Hague Convention, and how do they, for example, define habitual residence? Okay, so, and then finally, because this is a Supreme Court of Canada case, you can actually go to the Supreme Court of Canada. And they have case briefs that are available for the public that they've been working on not too long, but it is interesting to be allowed to go in and just read what is the Supreme Court of Canada deciding, and in plain language. So this case, the Belov decision is, I think it's around 161 paragraphs. The actual decision, the Supreme Court of Canada has given you a short synopsis. And then again, you can go to enact that. And they have also provided a little bit of a short synopsis. Here we are. Where they talk about the case. And now we're going to go back to so here again, the Supreme Court of Canada decision. When cases come up in the Supreme Court of Canada, they're quite important as it becomes the law of the land at that point. We do not have any, there is no court of law higher than the Supreme Court of Canada here in Canada. So once this decision came out, courts started implementing it. And the reason the Supreme Court of Canada decision of Belov came around, the fact situation was this. The parties, it was between, the requesting state was Germany. So the children had gone to Ontario and the parents had agreed. So there was some back and forth where the children would spend some time in Ontario, sometimes in Germany. So it was going back and forth for a period of time, but at the time where the Hague Convention came about, the parents before that had agreed that the children would be in Ontario for 16 months and go to school in Ontario, which they did. At one point, however, a dad who was the left behind parent, he said, no, I'm revoking my consent for the children to be in Ontario, and he started a Hague Convention application he started a Hague Convention application, and what ended up happening is at the trial level, the judge said, hey, how do I define habitual residence? And what was happening mostly in Canada at that time is habitual residence. They were looking at the intention of the parties. The intention of the parties, we're talking about the intention of the parents. Where was it that they resided and what was their intention. So basically, they're trying to decide where did they reside, where was their habitual residence of these children. They would look at the intention of the parties of where did they want their habitual residence to be. So here, for example, Dad had said 16 months you're allowed to go, and then you're coming back to Germany. So the habitual residence of the intention of the parties at that time, at least, was for the children to remain their habitual residence, to remain Germany. So at the trial level, the judge said no. Yes, the children should be returned to Germany. It then went on to the divisional court. The divisional court said no, the habitual residence of these children is Ontario. Dad then went to the Court of Appeal of Ontario and told the Court of Appeal of Ontario. The Court of Appeal said, we trust the trial judge's decision. The habitual residence of these children is actually Germany. There was no intention per se of the parties for their home to become Ontario. And then it went off to the Supreme Court. And one of the reasons that, again, the Supreme Court is the highest court of Canada, and they decide when there is conflicting areas of law, which is quite important. And most of Canada, I would say at that point, was looking at intention of the parties, what the Court of Appeal of Ontario looked at, but the Quebec Court of Appeal was not. The Quebec Court of Appeal actually was using the hybrid approach since 2017, which is the approach that the Supreme Court of Canada adopted for deciding what is the habitual residence. And that is now how we will define what habitual residence is. So when I'm talking about this, I'm telling you in April 20th of 2018, there was a change in how we define this quite important term. And the question then becomes, how has it been applied otherwise? Well, if we go to Ludwig and Ludwig, this is a court case from 2019. This is the Ontario Court of Appeal decision. And how do I know this? Well, first of all, up here it says Court of Appeal for Ontario. Here we know the name of one of the parties was Niles Christian Ludwig, and then Jennifer D. Ludwig is the respondent. Okay. And here is where the Court of Appeal uses the they apply the bell of decision, and they say, okay, this is what the steps are now, and the steps are set out quite completely in paragraph 40. Okay, so this is how the framework of the Hague Convention works here in Manitoba and in Canada in general. Okay, so stage one, we're looking at where is the habitual residence of these children. And this is where we have looked at the hybrid approach. So we are not just looking at intention of the parties, we are taking into account other factors, which would have been child-centric, is some of the factors that would have been under the child-centric model, where we really care about what the children need. Okay, so stage one is the habitual residence. On what date was the child allegedly wrongfully removed? That's important. So immediately before the date of the alleged wrongful removal, which jurisdiction was the child habitually residence? And when we're trying to come up with this answer, what do we look at? You look at the focal point of the child's life, so their family, their social environment, and the life that they had developed immediately prior to removal. Okay, so we're not looking about where is it now when we're talking about habitual residence. We're talking about before the removal, where was this? And then the court is supposed to look at the focal point of the child's life, and they have to look at three kinds of links. The first one is the child's links and circumstances in country A. Okay. The second one is the circumstances of the child's move from country A to country B. So why did the child move from country A, which would have been the place who is the, I guess, the requesting state at that point, the state that is asking for the return of the children. So what is the circumstances that they move the child from country A to country B? And then what are the circumstances and the links of the child to country B? So when you're looking at these factors, what are you also going to be trying to use to determine these factors? Well, the child's nationality, the duration, regularity, and conditions and reasons for the child for being in country B, and the circumstances of the parents, including the parental intention, which was our main test before. So based on that, then there are two outcomes here. You can either find that, hey, nope, the child's habitual residence is actually not the requesting state, so Hague application is dismissed, or you can say that yes, the requesting state is actually the habitual residence of the child before they were wrongfully removed, and then you go to stage 2 of the analysis. And the stage 2 of the analysis is where we're looking at those exceptions, right? So one of the exceptions is that they're not actually exercising that custody or consent that they had rights to. And then 13B is, hey, this is the grave risk portion that we'll be talking about a little bit more later when we look at the other two cases that are Manitoba, from Manitoba. And here are some other exceptions. So again, how did I get here? I went on to Canley. I looked up Ludwig and Ludwig as a case. And section 40 is a place where they're actually very concretely telling you what is the new steps based on the Bellow decision in Canada. And how do I know that, hey, this is actually something, this is the Court of Appeal of Ontario. How is it that we know that this is actually important here in Manitoba? Well, if I go to cited cases, so these are court cases that actually look at Ludwig, and I do NB. Here we are. Okay, so Souza and Karen is a 2019 case from Manitoba. MBQB means Manitoba Court of Queen's Bench. And Munis is another one that talks about this portion. Okay. So I hope that's sort of helped in trying to find cases and be able to read cases in this.
Zahra, this is very interesting. Thank you so much. So two kind of quick questions. So the first one is, all these like websites that you've shown us up to this point, anybody can access them?
Yes, definitely. They are free. I do not have special access to them. They are on the internet. As long as you know where to look, you can find these websites. Yeah, and they are about access to justice. That's the reason these websites were created, is to increase access to justice, because the laws affect people. So people should know about the law and how they can be informed about it.
Mm-hmm. Perfect. Okay, and my next questions is, if somebody was to apply for the Hague Convention, mm-hmm. What would like a general timeline, like, is this something that would take years? Is this something that would, be a couple weeks? What might somebody expect?
Yeah, for sure. So part of the importance of the Hague Convention is they're saying that, hey, look, we want this to actually be expeditiously resolved. So if we again go back to the Hague Convention itself, text of the convention. Okay, so Article 2, it says contracting states shall take all appropriate measures to secure within their territories the implementation of the objects of the Convention. For this purpose, they shall use the most expeditious procedures available. And we do that in Manitoba. Part of it is we'll sit down and we'll talk about the procedure of getting that through. Part of it is that you'll have access to the central authority. Part of it is, for example, there's no needs for case conferences. As of there has been a new procedure that came into Manitoba as of 2018, February 1st of 2019. February 1st of 2019, we have a new procedure in Manitoba. Hague Convention does not fall under it. So you will get in front of a judge as fast as possible. But to answer your question, we'll move on to the two cases that we are going to be looking at from Manitoba. So again, we're going to go to Canley. The first case we'll be looking at is Mabaya Negalula. And this is the parties were in, the requesting state was the United States, okay? And specifically the state of Iowa is where they were considering it. So this is the case. So this is a Manitoba decision that we're looking at. So who is it between? It's Simon Mapoya Mabaya and Rachel Kabangal Negalula. And here is, you would see who are the lawyers. The central authority lawyer is listed here. And mom's lawyer is listed here. So here in this example, it is dad who is the left behind parent and mom is the taking parent. And I make no, the vocabulary, I find it quite invasive of a left behind parent versus a taking parent, especially when you're dealing with domestic violence cases. However, this is vocabulary that comes straight from the people who work in the Hague Convention. So that's why I'm using it, but going forward, I'll just be using mom and dad. So this is the court docket number here in Manitoba. So FD 1801-20497. So if we have this, we can actually go to the court registry. And again, this is our Manitoba court registry system. We're one of the few jurisdictions where you can just go online and have a look. And you can do a file number search. And this is FD18. We're just going to remove this. Those spaces in between there where I was copying and pasting. Here's the case. So here we know it is the right case because the names match. And by the 30th of August, there was a requisition put in at the courts saying that, hey, there is a Hague Convention case coming. So that's just to sort of hold the place. So that the mom can't go to court and put in a custody order. They will know that the Hague Convention is coming. It's just to save the space and open up a file for it. And the decision came out on the decision came out by the 8th of November. Okay, so by the time dad was in court was 30th of August, September, October, a little bit of November. So it's relatively quickly when we're looking at cases in family law or just civil cases in general. So Manitoba takes that quite seriously. And the other part of it is it has become even more, I would arguably say even more serious since the Bell of decision of the Court of the Supreme Court of Canada, because if we look at the Bell of decision at paragraph 89, see if I can just quickly search it. No, we have to go down. Okay, so this is what the Supreme Court of Canada's majority decision said. So it was a little bit split. There were some judges who went the habitual residence, the way they defined it was the intention of the parties, but the hybrid approach is the one that is now the law in Canada. And the majority's decision says, in light of this appeal, this court has taken steps to ensure the Hague Convention cases are flagged internally and expedited by our registry. I hope other Canadian courts will consider what further steps they can take to ensure Hague Convention proceedings are determined using the most expeditious procedures available. Judges seized of Hague Convention applications should not hesitate to use their authority to expedite proceedings in the interest of the children involved. Unlike much civil litigation in Canada, Hague Convention proceedings should be judge-led, not party-driven, to ensure they are determined expeditiously. Okay, so this is the Supreme Court of Canada telling lower courts this is an extremely important area, and that judges can, it can be judge-led. So judges can take steps to ensure that it is complied with and it's done well. And now that we go into the Mabaya decision, you'll see what Justice McPhail did, which was quite impressive and was ensuring that safety of the mother was protected. Even if the mother, even though she ordered the children to go back to Iowa. But here it is. Okay, so we're now into the Manitoba decision again. So here is, it's between these two people. The judgment was delivered on November 8th, 2018, as we have seen on the court registry. And here are the facts of what has happened in this particular case. The first thing is that the state requiring the children to come back is Iowa. Okay, and what ends up happening is you get a little bit of background on the parties. So they were, the mom had, the mom was a Canadian citizen, but she also received a green card. The parties were actually married here in Winnipeg, I believe. Yeah, they were married here in Winnipeg, but he returned to Iowa. She went back to Iowa, and then they had some. It got to the point where mom ends up leaving with the children because of domestic violence in the home. And it gets to the point where one of her family members comes and drives her to Manitoba. And there was some questions on whether or not this this was appropriate or not. Dad starts a Hague Convention proceedings when he finds out, yep, no, mom's not coming back. And in this particular case, it's here we're talking about the children. Yes, they are under the age of 16. Yes, Iowa is under United States of America, so it is a contracted state between the convention, so between Canada and the United States. No questions asked. They are a contracting state. Yeah, and at one point, and obviously the father had custody rights under Iowa law as well. How can I get rid of this? There we go. Okay, so the mother didn't argue habitual residence of the children. The children were in Iowa, and she had come here, and they were supposed to be here for a couple of months. But after that, the mother did not argue that, hey, the habitual residence was actually here, which makes sense based on the fact situation of that case. Okay, but what the mother does argue is that, hey, the father actually acquiesced or consented after the fact. So that exception was something that she argued under. And then the second one is that the Article 13b, which there is a grave risk to the return of the children. Okay, so Justice McPhail went through it, and the first question she asked is, look, we're not actually arguing habitual residence. The mother is consenting that Iowa is the habitual residence. All she's arguing for is the exceptions. The first exception is 13A, that father subsequently consented or acquiesced to the retention of the children. So afterwards, he said, yep, the children can stay there. There was consent. And based on this fact situation, it wasn't found between, yes, originally the father allowed the mother to leave, but there wasn't any consent in these fact situations that he could keep the mother. She could keep the children in Canada, and there was some text messages between the parties, but there wasn't anything significant. Yeah. Okay, so here paragraph 46 and 47, Justice McPhail is talking about what does consent and acquiescence mean, and she's saying, hey, it's just the ordinary meaning of these words. So they're just consistently interpreted by the courts to be their ordinary meaning of consent. So there was some text messages between the father and the grandfather, who is the mother's father, that talked about the parties trying to work on their relationship, that he was apologetic in some of these text messages, but there is no clear and cogent evidence of unequivocal consent or acquiescence. And the other important part is that he actually, the idea that he sent off text messages saying, yes, I'm okay with it, and then within a very short period of time, he was actually in touch with the American Central Authority, so the Iowa Central Authority, to get the children back from Canada. The court found that, no, there's no reason to think that there was acquiescence here. And then, so, yep, there isn't an exception under the fact that he consented or acquiesced. The second part of it is this section 13b of where is there grave risk. Okay, so grave risk to the children, that it would be intolerable for them to return. Okay, in this particular instance, what is really quite important is to look at what does it mean for it to be grave risk. So the court says that, look, there is an extremely high threshold to establishing, so the standard is quite high for you to be able to establish that there is grave risk that would stop the return. Okay, so there'll be an exception to the return. And the court specifically looks at an Ontario decision in Ellis and Wenzel Ellis. It's a 2010 Ontario Court of Appeal decision where the court says that case was between England and Ontario. So the requesting state was England. So the court says, aside from recognizing that English courts are the appropriate forum to determine the merits of custody case, a return order also recognizes and trusts that those courts are capable of taking necessary steps to both protect and provide for the mother and the child in the present case. This is what underlies Article 13b and why there is such a high threshold for parents wishing to justify removing the children from one contracting state to another. Okay, so they're saying that, look, we recognize that they're the appropriate place to make this decision because the children are there, their information is there. We can actually access things there. The second part is that those courts are capable of taking necessary steps to provide for the mother and the children. So that's why it takes the threshold quite high. And that's where, in this case, the mother fails because Iowa is seen as an appropriate jurisdiction and can also provide her with safety. So there is, although there is domestic violence in these cases, and although domestic violence will result that that children can be affected by domestic violence, that's not arguable here in Manitoba. But what is arguable is when do you meet that threshold? And cases where the court, if you look at paragraph 65 here, cases where the court has found it to be extremely clear of the evidence of domestic violence to such an extent where Article 13b actually applies, the courts have looked at photographs of injuries, third parties including police evidence of violence, medical evidence of injuries, granting of protection orders, criminal charges, and inability of the authorities in the other place to restrain the abuser. So that's what's quite important, to be able to get past that high threshold. You need quite a bit of evidence, and you have to be able to show that there isn't any availabilities in that state. In this case, there wasn't any evidence of that nature that mom could provide. And the reason for that is that although domestic violence was occurring in the home, mom, because of cultural and religious reasons, she didn't feel comfortable talking to police. There had been an incident where she eventually she talked to her employer, and her employer had police come to her house, but she refused to talk to police at that time. But she did feel safe to leave and come to Manitoba. So what Justice McPhail did in this decision is, again, when we're looking at paragraph 89 of the Supreme Court of Canada decision in Belab, that says this is a judge-led process. Justice McPhail actually went through the system to connect with a judge in Iowa, and there was a conference held, a teleconference held between the two judges with the parties who could attend via dad attended in the courts in Iowa, and mom was here, where they had discussions about what are the safety mechanisms available in Iowa. And these are the questions that Justice McPhail asked, A, B, C, and D. And these questions were answered in that teleconference by the judge in Iowa. I believe his or her name was Anderson, Judge Anderson. And yes, there was ability to seek an order from the Iowa court for civil protection, and what the resources were and what the information was to facilitate the return of the children. So Judge McPhail said, look, here is, the importance here is that Iowa is capable of assisting her. She hasn't met that high threshold, and she did in her affidavit say I refused the assistance of police because I had been taught since I was a child that family conflict should be dealt with by the family and the assistance of the church. So the resources that were available in Iowa wasn't something that she knew of. But once Justice McPhail said, yes, the children must return, then Justice McPhail also provided her with a safety mechanism of how it would go. And part of it was that the address, her address, she would obviously not be sharing that when she goes back to Iowa, of how that would be done. All right. So the other things that's quite important when you have a Hague Convention application that starts up is that once we go back and we look at what is the procedure in Manitoba, part of it is that once a case is started under the Hague Convention application, they ask for the children's birth certificates. They ask for you to provide the passports. So you will not be leaving until this decision is made. So that's quite important to kind of know about. How's it going, Kat? Good? All right. Okay. So the other part that we're going to be talking about is going to be the other case that is a Manitoba decision, again, dealing with Section 13B, sorry, Article 13B, grave risk to the children. And just before we leave our 2018 Mabaya decision, we're just going to look at paragraph 74, where the court is saying that, look, if I'm ordering the return of the children to their habitual residence, which in this case is the United States, which is the city of Iowa, it is not an order that they must be returned to the care of the father. Okay, it is an order that they be returned to the habitual residence so that court can decide. So this doesn't mean that as soon as mom got there, she had to hand over the children to dad. It is not a custody order. And there were provisions in the order itself that said, hey, how is it that you'll be moving from Manitoba to Iowa? You're just going to be driving, for example, was one of the things, in that when she got there, she didn't have to share her information with dad right away. She did, however, have to tell the courts where she was going. Okay, so now we're on to Calicut. So Calicut is a decision where we do find Article 13B, which is the grave risk of harm, actually applies. And this, the children were not ordered returned because of the amount of abuse that was going on and the uncontrollable nature of the father in this case. So again, we just go on Canley, we pull up the case. And in this particular case, there were some, the requesting state is again the United States, but the state is actually called Guam, which is not one of the 50 states of America. It's actually a United States territory, but the country itself is still the United States, still applicable because Canada and the US, the Hague Convention applies to both countries. Here what we have is, was there a wrongful or removal or retention of the children? The court here finds yes, there was. And there is some back and forth here, where dad had actually gotten some assistance from his employer, he was in the Navy of the US, for the children to move with mom. But that was just a little bit fast-tracked because mom had to come back here for the funeral of her mother. So there wasn't ever an intention of the parties for mom to be allowed to leave and not come back within a month. And again, this case itself is from 2014. If we look here, and it's the date. Judgment delivered July 9th, 2014. This is before the Bell of decision from the Supreme Court of Canada. So the intention portion of this, of where is the habitual residence, it relies on the intention of the parties, which is no longer the law. So were the children habitually resident in Guam, this is where the Bell of decision has not considered because it didn't happen yet. But we will just move on to the domestic violence and grave risk exception on this one. Yeah. And also on the consent to remove, the court also found no, that the father didn't consent to remove. Yeah, so the father had gotten some money from his employer for the mothers to eventually move, but that was only if their situation in Guam, their family law legal decision had already been decided before his consent was actually valid. It was conditional on that being done. The domestic violence portion of it is quite significant here. And the court here says that what is, when we're talking about grave risk, what is the grave risk that we're considering? The court looks at another court decision, and in that, and they accept this because it is an important decision from Justice Lafave. So the definition is the risk has to be more than ordinary risk or something greater that would normally be expected in taking a child away from one parent and passing him to another. I agree that not only must the risk be a weighty one, but it must be one of substantial, not trivial psychological harm that, as it seems to me, is an effect in the words, as otherwise place the child in an intolerable situation. So when we're looking at that grave risk, and if we remember Mabaye, the threshold is high. This is what the threshold is, that would otherwise place the child in an intolerable situation. Okay, so now when we're looking at hey, what's happening to these children, and we're looking at what does grave risk mean, what does intolerable situation mean, we are looking at the history of domestic violence to an extent to see where do these parents, where do we think they're going to end up based on what the situation was. And again, when we're looking at the history of domestic violence, a return order would pose a grave risk to the child's well-being and would only serve to reinstate the child in a highly stressful and psychologically damaging environment. And the court also noted relatively limited familial support for the mother in the requesting state. So here the court's just going through the various definitions of previous cases to try and come up, to try and enunciate what are we talking about when we're talking about grave risk, what are we talking about when we're talking about intolerable situation, and what's important there. Okay, so domestic violence is definitely a factor when we're looking at grave risk. So the next part of it is when we're looking about when we're looking at grave risk, we also want to be corroborating the domestic violence. And that's what happened here. So what is the case itself is the father was in the Navy, so he would be going from post to post. The mother was a Manitoba, she was from Manitoba, and she would go with the father, and they had children who also had some disabilities as well. So what ended up happening is there was significant domestic violence in this relationship, and it was corroborated by third-party sources and who would be seen as impartial. There was military police that were involved. Depending on wherever dad was posted, there were incidences. Child Family Services was involved. They had court orders for protection in Guam, again, to protect mom. Again, there were findings that dad had been abusive. So these were quite important. And the court took that into account too when they were saying, hey, is it appropriate for mom to be making the grave risk exception? And has she met that high threshold? And the other thing important in this case is there was corroborating evidence that dad's violence was also directed to the children. So there were physical violence against both mom and the children, again corroborated by Child Family Services who were involved with the child protection agencies. They won't be called Child Family Services in Guam, but child protection agencies in Guam that were available. And there was also pictures of violence. So that was quite important in this particular case. And there was even evidence where dad had said, hey, my supervising officer had said, you should allow mom to leave because of the amount of violence. And yes, she shouldn't be allowed to leave until you guys sort things out in court here, but afterwards allow her to leave so that it can be paid for her to leave Guam. And again, injuries to the children were quite significant, and that the dad himself had signed a memorandum that so there was obviously concerns about the child abuse that was allegedly perpetrated by dad against the son. So based on the evidence here, based on the corroboration of evidence from third parties, the court said that, look, it is credible that the mother and the children were subject to long-standing pattern of domestic violence involving both physical and emotional abuse. And the court says that I am concerned, even with a protection order in place, this is in Guam, the father would not tend to respect it and would make attempts to contact the mother and the children, which would expose them to further physical and psychological harm. This is, again, the court has evidence of what dad did from third parties, that he was unable or unwilling to control himself, which put mom and the children at risk. And the court quotes another decision and says, when we are making this decision, is the danger of future harm lessened because the parties are no longer cohabiting? That's a question the court can ask themselves. And the court says, not necessarily. So although previously courts may have made that decision, now the courts would recognize that separation can mean a loss of control, and an abusive spouse is often anxious to reassert control. So that's again quite significant when the court is saying, look, he has demonstrated an ability to be controlled in Guam, and the amount of domestic violence is quite significant, and it's corroborated by other sources. There was even cases in the military courts against dad 3 times where mom was the victim. So again, quite significant. There were 7 cases in all. At times she said, no, I'm not going to go ahead with this, because she was afraid that dad would lose his job, and that she would not be able to be financially supported, and the children wouldn't have the financial supports that they needed. Right. So based on all the evidence that comes in, the court found that there is a grave risk that the return of the children would put the children and the mother in an intolerable situation. Mom doesn't have any funds in Guam, and previously the military provided her with some funding, but that again would not be something she would be entitled to now, because of she's no longer the spouse of the member of dad. They are now separated. She doesn't have any familial supports in Guam, and she doesn't have the financial resources to be able to visit Guam if the children are returned to Guam. So the court said, look, I'm satisfied that the returned order would place the children and mom in a financially and psychologically vulnerable position without any supports. And the court said the lack of financial means, lack of emotional support, and isolation has been found to satisfy intolerable situation test. And the court quotes Harris, the decision in Harris, and says, look, because of these decisions, I wouldn't be I wouldn't be ordering the children to be returned, although the children were, the habitual resident was Guam, although dad did not consent afterwards to the removal of the children because of the amount of domestic violence, the serious nature of the domestic violence, and also because of corroborating evidence, which is really quite important for the judge to be able to rely on it. The court said no, we will not be ordering these because it falls under section 13B of the article 13B of the Hague Convention. And that's it on this one. All right. So, and what are some other things that I can tell people? Well, one of the important things is if you are thinking that, hey, I may be in danger of having my children taken away from Manitoba, if you are in Manitoba, it's really quite important to have some information about the children, and be, so this is a website by the government of Manitoba, and it's called Preventing International Child Abduction. So it provides you with information of, hey, what is it that you should do? And who can you reach out to if you have questions? What do you do if your child is missing? You tell the police. And you want to be, how do you contact people? That's important. Contacting Passport Canada is also important. And in Manitoba, you can also reach out. If you reach out to police, they will put you in touch with the central authority, and you now know, hey, how do I find the contact information of the central authority as well? So the kind of kind of information that you need to have for your children is the name, date of birth, and citizenship of your children. that the other party's name, date of birth, and their citizenship. That they are going to look for a detailed accounting of what was the situation. They're also going to be looking at photos of the children, birth certificates of the children, copies of the passports of the children. So these are kind of things that you will be asked for. So it's good to have copies of these, or at least know where you can get copies of these, and provide some assistance. And then the other thing is, if you are the left behind parent and your children are in the other jurisdiction, there is an order for them to be returned here to Manitoba, and you cannot fund it. And for whatever reason, the court hasn't ordered dad or the taking parent to fund it. There is some travel reunification services that is provided for parents like that. And that is everything. Well, thank you so much for hanging out with us.
Great. Thank you, Zahra.